Good afternoon, everybody. I want to thank you and I appreciate you. So, I want to come with some sauce. You know what I'm saying? A little bit of sauce. Don't get lost in the sauce. Always, learn and learn and learn. That's why I like being a student in a perpetual school of life. And hopefully, I can graduate with honors when I'm passed. So, we want to talk about the beauty of understanding your role in regards to agreements and contracts and why you need to understand your role, your responsibilities, and you may have to ask if you don't know. There's nothing wrong with asking. Okay, nothing wrong with asking a bank, a financial institution, or whatever they have available. Sometimes you guys ask questions to random strangers, except for the people you're doing business with, like being in a relationship, having a problem with your significant other, and then going to her cousin and saying, "Hey, I have a problem with her," or "I have a problem with him." You didn't address the problem with the situation or the situation with the person who you have the problem with. So you're going to perpetually have a situation, regardless of how you handle it. Okay, a holder in a legal context, particularly in relationship to a negotiable instrument like promissory notes or loan agreements, refers to a person or entity in possession of the original document who has the legal right to enforce it. Here's how these concepts relate to your questions. Okay. One, does a holder act like a clearinghouse or could they act like one? A holder typically is not the same as a clearinghouse. I obviously know that. Okay. But I asked some of these questions to make the relationship closer so some of you guys can figure out the differentiation or how the variation still, like the terminology may change it, but the function is still the same. Okay. Though they might function similarly in some limited context, let's clarify the roles. A holder is someone who has possession of the original agreement or an instrument, such as a promissory note, and has the legal right to enforce the terms of that document. Okay? Now, if you gave someone a promissory note, right, you can either give it to them with restrictions, you can give it to them freely, or you can say, "Give me my damn instrument back." The holder may be the original lender, an assignee, or an entity that required the loan through a sale or transfer. Well, guess what? You're a holder too. If the bank holds the original promissory note, okay, it can demand payment or enforce the loan agreement. Y'all not hearing the information that this is saying. Listen to what it just said. If a bank holds the original promissory note, it can demand payment or enforce the loan agreement. Well, why have you not requested your promissory note? Y'all, boy, I'm telling y'all have so many remedies y'all don't even know. Y'all do not know. Okay? Clearinghouse. A clearinghouse facilitates the exchange of financial instruments like checks or electronic payments between institutions. It ensures that the transactions between banks and financial institutions are settled efficiently. Okay, this is where the Fed comes in. Okay, the Federal Reserve is a clearinghouse. Okay, they don't have to use money. What they do is they use an accounting system, a ledger-based accounting system. Okay, the role of a clearinghouse is to act as an intermediary to clear and settle payments, not to enforce individual loan agreements. Okay? So when you have the bank, you need to know what position are they acting in so you can facilitate and assist them. Okay? You if you want to assist them or if you want to cancel the agreement, I mean that's on you. All of these roles are your roles to take, but you have to take them on your own volition. I can't force you to do anything. While a holder can sometimes act in a capacity similar to a clearinghouse, for example, if the holder is a financial institution that services and processes payments on behalf of other parties, who are they servicing payments on? You! On behalf of you. You are just asleep at the wheel. This would generally fall outside of their role as a holder of the instrument itself. Why? Conflict of interest. A holder typically has a more direct role in enforcing an agreement, not merely processing payments between parties. Okay. Is a holder any person that holds a copy, certified copy, or an original of an agreement? No, not every person who holds a copy, certified copy, or an original of an agreement is considered a holder in a legal sense. Let's break this down. Okay. Original document. The holder in the legal sense typically refers to the person or entity in possession of the original agreement or the negotiable instrument, e.g., the promissory note. Okay. I only gave one person on one call a remedy for this. And when she got it, she's like, get the heck out of here. Only the person with the possession of the original instrument generally has the right to enforce it, assuming other legal conditions are met. Now, I still have a remedy for this. This will come out, and I'm going to show you this remedy. It's going to be fire. Okay, e.g., they are entitled to payment under the terms of the note. Okay, so they're in possession of the note. That note acts as prima facie evidence that they have the ability to receive payments. Okay, because there's no contradictory claims that are evidence in front of the note or claims to the note. They are acting as if they received the note free and clear with no encumbrances, which is right. So when people come to me, the bank is evil, the court is evil. No, you're ignorant. It's okay to be ignorant. We're all ignorant of stuff. I have stuff I'm ignorant of. Okay. Copy or certified copy. A person or entity holding a copy, including a certified copy of the agreement, is not legally considered the holder. A copy is usually for informational purposes or for legal file. Hold up. Wait. So, if somebody filed a copy in your foreclosure case, or if somebody filed a copy in your vehicle repossession case, or if somebody filed a copy in your child support case, why wouldn't you ask for the original instrument that you signed? But does not confer the legal right to enforce the instrument. Okay? This is what you guys are not understanding. When you're in child support, you're dealing in negotiable instruments. When you're in a traffic ticket, you're dealing in negotiable instruments. They may be non negotiable on their face, but they can be used by attachment, endorsement, assignment, deposit as a legal transfer of your interest. That's what you guys need to understand. Okay, the original document is what typically gives someone the authority to demand payment or otherwise enforce the terms of agreement. Okay, certified copy. Even a certified copy, this is for people who allow LNAs, which is lost note affidavits, which you should vehemently challenge that. Even a certified copy, which is a copy verified as true to the original, does not carry the same legal weight as the original for the purposes of enforcing the agreement. Now, let me tell you where I learned this at before I even got on this damn robot. I learned this from court. Okay, when I used to go down to court and battle with Milwaukee County, right? What they would do is the clerks were so foul down there because they didn't know the law. You see what I'm saying? So the clerks don't make that much money, so they're so rude and foul. She said, "We have to have a copy of the original. We have to have the original." I said, "Why would you have to have the original when I'm the holder of the original? I have the right to give you a copy. I have the legal right to give you a copy of my filings." So me and this clerk go back and forth. Now all of a sudden they change their policy. Oh, we only need a copy. So they had to retrain their staff. That's why y'all don't understand. A lot of times when y'all go into court, y'all will be training these people by asking questions and bringing laws and showing them what they're supposed to do. You see what I'm saying? You can tell your lender what they're supposed to do. And if not, you can use that as evidence that they're failing to comply with federal and state rules. Okay? A certified copy may be used for legal purposes such as court proceedings. See? So if they try to get a certified copy, you say, you get the Kempe Matumbo with they ass and say, oh, no, 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 no. Use the same voice too. All right. So, but it is not equivalent to the possession of the original for the enforcement of rights. Now, what attorneys will do, is they will tell you that this is the original note, but you haven't verified it. The only person that can verify the original note is the person who signed it, not the person who's in possession of it. The person who signed it is the only person that can verify the original copy of the note. You guys don't, when you are in foreclosures, you do not understand how much power you have. This is why I try to tell you guys, if you act expeditiously and you follow the court guidelines, you will win 100% of the time. If you don't, you will lose, or it will take you longer to get your win. You see what I'm saying? Because you never lose in court until you give up. Okay. Summary: a holder is generally the entity or person in possession of the original instrument. So a holder can be a servicer, it can be anything. You know what I'm saying? They use dual roles and all this other stuff. Okay. So technically, this is right, but it's not right. You know what I'm saying? A holder, because if I go to the UCC over here, it'll tell me something different or not. Okay. So it tells me, go down to the H's. A holder means a person in possession of a negotiable instrument that is payable either to bearer, which means when you sign an instrument on its face, that's a bearer document. Okay. If you don't say how it's supposed to be moved or what it's supposed to be done, it is a bearer document. Or to the person, or to an identified person that is in possession. Okay. Or the person in possession of a document of title. Okay. So now you need to know, what is a document of title? So a documented title includes bill of lading, doc warrant, doc receipt, warehouse receipt, or order for the delivery of goods. What do you think the agreement is? An order for the delivery of goods, but you never purchase it. And also any other document which in regular course of business of or finance is treated as adequately evidencing a person in possession of its entitled to receive, hold, and dispose of the document and the goods it covers. Doesn't that sound like every bill they send you in the mail? Doesn't that sound like every agreement you're in? Yes, it is. To be a document of title, a document must purport to be issued by or addressed to a bailee and to purport to cover goods in the bailee's possession. What do you think that bill is doing? It's all there, baby. It's all there, which are either identified or are fungible portions of an identified mass. Okay. I had a person I did a consultation with, and they had an issue with child services. I said, because you never claimed your property, your child is your property. So why are you letting these randos claim your child and use them as a bartering chip? Look, a holder is generally the entity or person in possession of the original instrument, e.g., so they're using their content. It doesn't matter. If I have a reference that somebody is in a possession of an instrument, I can establish that chain of title and get that instrument back. But I'm not even going there. I'm going to bring it. I'm saving some of this for my private course that's coming up. Okay. A promissory note with the legal right to enforce its terms. The holder role is not the same as a clearinghouse. Now, the holder, they're just saying, now I have to remember when I'm using this that you have to be very technical with things, right? You have to be very, very technical because this is like talking to a baby. So I had to tune this to get to this level of knowledge. It wasn't just like it just had all this knowledge. It's listening to what I'm telling it. Okay. Through certain financial institution acting as a holder could, though certain financial institutions acting as a holder could also perform clearing functions. See, some of you guys do not understand that every financial institution does not have the ability to process notes, drafts, and securities. Every every bank does not have that authority. Some banks do. And some banks have to partner with other banks because they have the authority and they don't. That's why you have stuff like warehouse lending. Okay. So, because some banks have different clearances and different authorities and different things that they can perform behind the closed doors. Not all banks are the same, or not all financial institutions are built the same. Okay. Holding a copy or even a certified copy of an agreement does not make a person a holder with the right to enforce the agreement. Only the entity with possession of the original instrument has the legal standing to enforce it unless other arrangements. So, what does that mean? Okay. If the ownership or right to enforce a loan or agreement is in question, the original instrument and its chain of title, who it is held, will be crucial. Okay. You have no document to fix the chain of title. And that is why you are subject, people. And with that being said, I wish this energy resonates with you. I hope that this message resonates with your soul. You really have to understand that you have no documentation to establish your rights, title, and interest in regards to the agreement. This is why the lender doesn't listen to you. And with that being said, I'm out. Oh man, I forgot to bring up what cologne I'm wearing today.